Give me free. Give me free. Writing for the majority in Loving Beach, Virginia, decided in 1967, almost 60 years ago, Chief Justice Warren wrote, "Marriage is one of the basic civil rights of man, fundamental to our very existence and survival." Citing to Skinner v. Oklahoma, cited in 1942, and Maynard v. Hill, cited in 1888. To deny this fundamental freedom on so unsupportable a basis as the racial classifications embodied in these statutes, classifications so directly subversive of the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state citizens of liberty without due process of law. The 14th Amendment requires that the freedom of choice to marry not be restricted by invidious racial discriminations. Under our Constitution, the freedom to marry or not to marry a person of another race resides with the individual and cannot be infringed by the state. Some people were happy about that result in that decision of the nation's highest court, and others were very upset. But in an adversarial system, as exists in the courts, and often in politics, that is simply the nature of the beast. But anyone who has had to tangle with civil and criminal procedure and local rules in litigation is fully aware that everyone, at least in a courtroom, is bounded by the rules. And in a rule of law, equally and equitably applied to all are then deemed to be treated equally under the law, that justice might then be blind. As I used to say in Little League and on the schoolyard, it doesn't matter whether you win or lose, it's how you play the game. And writing for the majority in Obergefell v. Hodges in 2015, just a few short years ago, Justice Kennedy wrote, "No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were. As soon as some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right." Some people were happy about that result in that decision of the nation's highest court, and others were very upset. But in an adversarial system as exists in the courts, that is simply the nature of the beast. For we are bounded by rules, and in a rule of law, equally and equitably applied to all are then deemed to be treated equally under the law, that justice might be blind. As they used to say in Little League and on the schoolyard, it doesn't matter whether you win or lose, but how you play the game. Hello, my name is Major Mike Webb, described as a fringe independent candidate for Congress, and everything but a child of God, as Mama used to say. And as a rambunctious son of a reverend who spent just a little bit of time with the Army Rangers, I tend to like to tackle the big fights, going guns blazing. And in this next contentious election year, one of the defining issues is that of abortion, and the incumbent's position, having been endorsed as early as December by Planned Parenthood, is pretty clear, as well as his position on church, religion, and God, aligning himself with the Freedom from Religion Foundation with their motto, "Not afraid to burn in hell." So, for the next few moments, let's just jump into the fire with him and begin with the landmark case regarding a reasonably expected consequence of a consensual relationship between a man and a woman in a hope that they not be condemned to live in loneliness, excluded from one of civilization's oldest institutions, and in a union that embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In Roe v. Wade, decided in 1973, Justice Blackmun described briefly the facts at issue, stating that Roe alleged that she was unmarried and pregnant, that she wished to terminate her pregnancy by an abortion performed by competent, licensed physicians under safe clinical conditions, that she was unable to get a legal abortion in Texas because her life did not appear to be threatened by the continuation of her pregnancy, and that she could not afford to travel to another jurisdiction in order to secure a legal abortion under safe conditions. She claimed that the Texas statutes were unconstitutionally vague and that they abridged her right of personal privacy, protected by the 1st, 4th, 5th, 9th, and 14th Amendments. By an amendment to her complaint, Roe purported to sue on behalf of herself and all other women similarly situated. So on the facts of this case, unlike in Loving v. Virginia and in Obergefell v. Hodges, the court was not presented with two consenting adults with a hope that they not be condemned to live in loneliness, excluded from one of the civilization's oldest institutions, nor that union that embodies in the highest ideals of love, fidelity, devotion, and sacrifice of family. Rather, the court had a person who, for whatever reasons, preferred to be alone, and who did not wish for her and her child a union that embodies the highest ideals of love, fidelity, devotion, and sacrifice of family. And Justice Blackmun observes in this case that there has always been strong support for the view that life does not begin until live birth. This was the belief of the Stoics. It appears to be the predominant, though not unanimous, attitude of the Jewish faith. It may be taken to represent also the position of a large segment of the Protestant community, insofar as that can be ascertained. Organized groups that have taken a formal position on the abortion issue have generally regarded abortion as a matter of the conscience of the individual and her family. As we have noted, the common law found greater significance in quickening. Physicians and their scientific colleagues have regarded that event with less interest and have tended to focus either upon conception, upon live birth, or upon the interim point at which the fetus becomes viable, that is, potentially able to live outside the mother's womb, albeit with artificial aid. Viability is usually placed at about 7 months, 28 weeks, but may occur earlier, even at 24 weeks. The Aristotelian theory of immediate animation that held sway throughout the Middle Ages and the Renaissance in Europe continued to be official Roman Catholic dogma until the 19th century, despite opposition to this ensoulment theory from those in the church who would recognize the existence of life from the moment of conception. The latter is now, of course, the official belief of the Catholic Church. As one brief amicus discloses, this is a view strongly held by many non-Catholics as well, and by many physicians. Substantial problems for precise definition of this view are posed, however, by new embryological data that purport to indicate that conception is a process over time rather than an event, and by new medical techniques such as menstrual extraction, the morning after pill, implantation of embryos, artificial insemination, and even artificial wombs. In areas other than criminal abortion, the law has been reluctant to endorse any theory that life, as we recognize it, begins before live birth, or to record legal rights to the unborn except in narrowly defined situations, and except when the rights are contingent upon live birth. And so while this case is very often framed under the context of being a right of a woman to elect to terminate her pregnancy, it is clear that the court in Roe v. Wade moved very far away from that idea and very fast, beginning to discuss those great philosophical, theological, and medical questions regarding the point during a term of pregnancy at which the law might recognize that as a living person. And this is a legally significant moment in the law, giving rise to a state's compelling interest. For as stated in the case U.S. v. Amistad in 1841, a case presenting facts with which many are familiar, involving a Spanish schooner that had been commandeered by Africans after departing Port of Havana and steered not to Miami but to the state of New York, and in which Justice Story had noted that the ship and cargo and Negroes were duly documented as belonging to Spanish subjects, and this court have no right to look behind these documents, that full faith and credit is to be given to them, and that they are to be held conclusive evidence in this cause. And as noted in Dred Scott v. Sanford, decided in 1856, the power of Congress over the person or property of a citizen can never be a mere discretionary power under our constitutional form of government. The powers of the government and the rights and privileges of the citizen are regulated and plainly defined by the Constitution itself. Thus said Justice Taney. Hence, under the law, when we speak of abortion, the subject matter beyond the choice of a physician or of a woman or of a parent revolves squarely around whether there is a life within the womb or merely a mother's property. And in Roe v. Wade, Justice Blackmun decided that the point of viability was decisive on this issue of deeming the subject a person or property. And for the period of pregnancy prior to this compelling point, the attending physician, in consultation with his patient, is free to determine without regulation by the state that in his medical judgment, the patient's pregnancy should be terminated. If that decision is reached, the judgment may be effectuated by an abortion free of interference by the state. Justice Blackmun further explained that, with respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justification. If the state is interested in protecting fetal life after viability, it may go so far as to prescribe the abortion during that period, except when it is necessary to preserve the life or health of the mother. And deciding the case involving the cargo aboard the Amistad, Justice Story noted that if these Negroes were, at the time, lawfully held as slaves under the laws of Spain and recognized by those laws as property, capable of being lawfully bought and sold, we see no reason why they may not justly be deemed, within the intent of the treaty, to be included under the denomination of merchandise, and as such ought to be restored to the claimants. For upon that point, that compelling point, the laws of Spain would seem to furnish the proper rule of interpretation. Is the subject in an abortion like the lawful property of Spain in the Amistad case? It's a question you must ask yourself in this midterm election. Justice Story observed, if then these Negroes are not slaves, but are kidnapped Africans who, by the laws of Spain itself, are entitled to their freedom and were kidnapped and illegally carried to Cuba and illegally detained and restrained on board the Amistad, there is no pretense to say they are pirates or robbers. Are the subjects of an abortion like the kidnapped African, brought aboard a vessel without their free consent or choice, detained and restrained aboard, like the cargo aboard or Africans aboard the Amistad? This is your choice in this midterm election. Well, Justice Story in a decision that became a summer blockbuster movie, had decided that when the Amistad arrived, she was in possession of the Negroes, asserting their freedom. And in no sense could they possibly intend to import themselves here as slaves or for sale as slaves. Give me free. And this year, with the most important issue arising on the subject of abortion, how do you want this Amistad voyage to end? This briefing is unclassified, as you were. My name is Major Mike Webb, and by God, I am running for U.S. Congress. This year, make the right choice, and we shall make America great again. Honest. Carry on. This advertisement was authorized by Mike Webb.